Hello everyone. Today in this particular video lecture we will be discussing how the criminal justice system is set in motion, what is trial, what are the stages of trial, what is pre-trial and what are the stages of pre-trial. So let's get started. Basically the stages of trial process has been categorized into two categories. Number 1, pre-trial stage and secondly trial stage. First of all, we will discuss pre-trial stage. Before we start, we need to understand what is trial. Trial means nothing but it is a structured process of court. In trial, where both parties come to present the facts of the case or dispute to the magistrate in the form of evidence. And the magistrate, considering all the facts and evidence presented to him, he decides if the defendant is guilty or not. All these proceedings, like during trial, prosecutor uses witnesses, evidence to prove to the magistrate that the defendant committed the crime, and then the defendant will deny or accept it. Both sides present evidence to show what actually happened. Arguments between prosecutor and defense counsel, cross-examination of witnesses, testimony, physical evidence such as documents, articles, weapons, etc. to produce before the court. And finally, the court decides the case based on the evidence and documents. All this proceeding in the court is known as trial. Here, one thing is to remember that there is a difference between civil cases trial and criminal cases trial. In a civil cases where parties come to the court to resolve their disputes. In a criminal cases, the state is represented in criminal trials by a prosecutor. ପ୍ରାୟ ସମୟରେ ଟ୍ରାଏଲ୍ ଶବ୍ଦଟି ଆମେ ଶୁଣିଥାଉ, ଯେପରି ଆସନ୍ତା ଏତିକି ତାରିଖରେ ଟ୍ରାଏଲ୍ ଅଛି, କୋର୍ଟରେ ଟ୍ରାଏଲ୍ ଅଛି ଇତ୍ୟାଦି ଇତ୍ୟାଦି। ଟ୍ରାଏଲ୍ ମାନେ ବିଚାର ଏବଂ ଏହା ଏକ ଅଦାଲତର ପ୍ରକ୍ରିୟା ମଧ୍ୟ, ଯେଉଁ ପ୍ରକ୍ରିୟା ମାଧ୍ୟମରେ ମାନ୍ୟବର ବିଚାରପତିଙ୍କ ଉପସ୍ଥିତିରେ ଉଭୟ ପକ୍ଷ ପ୍ଲେଣ୍ଟିଭ୍ ଆଣ୍ଡ ଡିଫେଣ୍ଡାଣ୍ଟ, ବାଦୀ ଓ ପ୍ରତିବାଦୀ, ଏବଂ ଅପରାଧ ମକଦ୍ଦମାରେ ଭିକ୍ଟିମ୍ ଆଣ୍ଡ ଆକ୍ୟୁଜ୍ଡ ବା ପୀଡ଼ିତା ମାନେ ଯିଏ ଅଭିଯୁକ୍ତ କରେ, ଅଭିଯୁକ୍ତକାରୀ ଓ ଅଭିଯୁକ୍ତ ନିଜର ସାକ୍ଷୀ ଓ ପ୍ରମାଣକୁ ଅଦାଲତ ଆଗରେ ଉପସ୍ଥାପନ କରିଥାନ୍ତି। ଉଭୟ ଓକିଲଙ୍କ ମଧ୍ୟରେ ଜବରଦସ୍ତ ଯୁକ୍ତି ହୁଏ। ସରକାରୀ ଓକିଲ ଅଭିଯୁକ୍ତକୁ ଦୋଷୀ ପ୍ରମାଣ କରିବାକୁ ଚେଷ୍ଟା କରେ, ଡିଫେନ୍ସ କାଉନସିଲ୍ ତାକୁ ଅସ୍ୱୀକାର କରେ। ମାନ୍ୟବର ବିଚାରପତି ମହୋଦୟ ଉପରେ ବସିଥିବେ, ତଳେ ଦୁଇ ସାଇଡ଼୍ରେ ଦୁଇଟି କାଠଗଡ଼ା ଥାଏ, ଯେଉଁଠି ଛିଡ଼ା ହୋଇ ସାକ୍ଷୀମାନେ ସାକ୍ଷୀ ଦିଅନ୍ତି। ଉଭୟ ଓକିଲ ପ୍ରଶ୍ନ ପଚାରିଥାନ୍ତି, ତାରିଖ ଘୁଞ୍ଚିଯାଏ, ଏସବୁ ପ୍ରକ୍ରିୟା। ପରିଶେଷରେ ଅଦାଲତ ଉଭୟ ପକ୍ଷକୁ ଶୁଣି ସାରିଲା ପରେ ସମସ୍ତ ସାକ୍ଷୀ ଓ ପ୍ରମାଣକୁ ଭିତ୍ତି କରି ନିଷ୍ପତ୍ତି ନେଇଥାଏ ଏବଂ ନ୍ୟାୟ ପ୍ରଦାନ କରେ। ଏହିସବୁ ପ୍ରକ୍ରିୟାକୁ ଟ୍ରାଏଲ୍ ବୋଲି କୁହାଯାଏ ବା ବିଚାର ବୋଲି କୁହାଯାଏ। Okay. Now we will understand pre-trial stage. In pre-trial stage, investigation, FIR, discovery process, finding of facts, etc. is conducted. We will discuss one by one the whole process of pre-trial conducted before the beginning of court trial. ଯେତେବେଳେ କୌଣସି ଅପରାଧ ଘଟେ, ସର୍ବପ୍ରଥମେ ଥାନାକୁ ଯାଇ ଘଟଣା ସମ୍ପର୍କରେ ପୁଲିସକୁ ସୂଚନା ଦିଆଯାଏ, FIR ଲଜ୍ କରାଯାଏ। ତାପରେ ପୁଲିସ ମାମଲାର ତଦନ୍ତ ଆରମ୍ଭ କରେ, ଘଟଣାର ଛାନଭିନ୍ କରି ସତ୍ୟତା ଓ ପ୍ରମାଣକୁ ଖୋଜି ବାହାର କରିଥାଏ। ଅଭିଯୁକ୍ତକୁ ଗିରଫ କରାଯାଏ। ଅଧିକ ପ୍ରମାଣ ବା ଅନୁସନ୍ଧାନ ପାଇଁ ଆସାମୀକୁ ପୁଣି ଥରେ ହାଜତକୁ ପଠାଯାଏ। ଘଟଣା ସମ୍ପର୍କରେ ପ୍ରଶ୍ନ ପଚରାଯାଏ, ଯାହାକୁ ରିମାଣ୍ଡ ବୋଲି କୁହାଯାଏ। ଏହିସବୁ ପ୍ରକ୍ରିୟା ପ୍ରି ଟ୍ରାଏଲ୍ରେ ହୋଇଥାଏ। So, there are 4 heads under pre-trial stage. Number 1, registration of FIR provided under section 154 of the Code of Criminal Procedure 1973. Number 2, investigation. Section 156 to 159 CrPC, that is the Code of Criminal Procedure 1973. Arrest. And the last one is remand. Let's first look at the registration of FIR. The registration of FIR is provided under Section 154 of CrPC, that is the Code of Criminal Procedure 1973. FIR, that is the first information report which sets the criminal law into motion, quote unquote, very important, and it has the very important bearing in the criminal court process. Here we need to understand that why lodging FIR is so important, why criminal law should be set in motion. Remember, the word FIR has not been defined in the whole CrPC. पूरा CrPC रे FIR को कौनसी जगह रे डिफाइन करा हैनी. This is why we say first information report, because in section 154 of CrPC, which deals with information in cognizable cases, means to give information to an officer in charge of a police station relating to the commission of a cognizable offence, and police register FIR in writing under this section, section 154 of CrPC 1973. If any cognizable offence is committed, first of all, you are going to police station to register the FIR. You are not going directly to court or anywhere. କୌଣସି ଗମ୍ଭୀର ଅପରାଧ ଘଟିଥିବା ସମ୍ବନ୍ଧୀୟ ସୂଚନା ସର୍ବପ୍ରଥମେ ପୋଲିସକୁ ମିଳିଥାଏ କିମ୍ବା ଦିଆଯାଇଥାଏ. ତେଣୁ ଏହାକୁ ପ୍ରଥମ ସୂଚନା ରିପୋର୍ଟ ବା ଫର୍ଷ୍ଟ ଇନଫର୍ମେସନ୍ ରିପୋର୍ଟ କୁହାଯାଏ. କିନ୍ତୁ ଆପଣମାନେ ଯଦି ଧାରା 154 ଦଣ୍ଡ ପ୍ରକ୍ରିୟା ସଂହିତା 1973 ପଢ଼ିବେ, ସେଥିରେ କୌଣସି ଜାଗାରେ FIR ଶବ୍ଦ ଲେଖା ହୁଏ ନାହିଁ. A very important thing is to understand here is that the basic purpose of filing FIR and by filing FIR, how criminal law sets into motion. The term sets into motion. Sets into motion means to start something moving, to commence or to begin. Criminal law should be set in motion in order to protect peace and harmony in the society. Failure on the part of the individual to set the criminal law into motion would lead to demoralization and disorder in society. Therefore, it is an accountability upon every individual to set the criminal law in motion, and it is the duty of every individual to set the criminal law in motion when the circumstances raises for the same. So, let's understand briefly what is criminal law. Any act or rule dealing with crime is known as criminal law. The criminal justice system is a firmly society defensive reaction to intolerable behavior. Okay. Criminal law is the system of law that punishes people who commit crimes and other various types of criminal act. Here, criminal acts means it is a conduct like threatening, harmful, or endangers the property, health, safety, or moral welfare of another. The main objective of criminal law is to protect the rights of individual, to protect peace and harmony in society. Criminal law defines what is wrong, what is right, and it prescribes punishment or sanction for failure to abide by its rules. Alright, till now we understood what is criminal law, what is criminal act, and we discussed little bit about FIR also, and we knew that we have criminal laws such as CrPC, evidence, IPC in our country. So many acts, rules relating to criminal laws made by Parliament and laws made by Supreme Court of India. Remember, the judgment of Supreme Court of India itself became a law of the country, which every citizens of India must obey. So we have everything, set of rules, codified act written in the book. But the question is how this criminal law will function, when it will come into effect, how it will work. We said that criminal law works as a defensive to the society. It helps in securing the protection of every individual, protects the rights of every individual, safety in society, maintaining peace in society. It punishes the wrongdoer, etc., etc. But how the criminal law will be initiated and how it will start functioning. Just remember, in the in the beginning in the beginning of this lecture, I have said the term, that is how criminal law sets in motion and why criminal law should be set in motion. The word set in motion means to commence, to start something moving, also to initiate, we can say. The basic the basic purpose of filing FIR is to set the criminal law into motion. Set the criminal law into motion. This is very important. And not to state all the minute details therein. You don't need to write all the story. You just need to write the material things. What happened? That's enough. FIR FIR may be said to be a document which sets the criminal law into motion, therefore has a great evidentiary value. But it is not a substantive piece of evidence, nor it is the conclusive evidence of the facts which it mentions. The lodging FIR sets the criminal law into motion and to conduct investigation by police officer. So, to start conduct investigation with regard to commission of a cognizable offence, or to initiate the proceeding against the wrongdoer, or to punish the offender who commits such wrong, and to get justice of someone against whom such offence has been committed, that it is mandatory to register an FIR on cognizable offence. Without lodging FIR, criminal law is just obsolescence. For example, if any cognizable offence has been committed against you, like murder, rape, dacoity, etc., then you need to inform police and to register an FIR. Instead of doing this, if you sleep at home like nothing has happened to you, not even informing to anybody about the incident, it may be the reason of fear of adverse or for the fear of losing respect, honor of the family in society. But you must inform police about the offence committed, because police has no information earlier. Police will not visit to each house to ask whether any offence has committed, or do you want to file case against the offender, or do you want to get justice, etc. No, it's not like that. So it is pretty clear that an FIR plays a vital role in criminal proceeding to set the criminal law into motion. This is why we say it first information report, because you are informing first to police officer about the cognizable offence committed to investigate or to proceed on that matter. FIR ଲଜ୍ କରିବାର ମୂଳ ଉଦ୍ଦେଶ୍ୟ ହେଉଛି ମକଦ୍ଦମାକୁ ଆରମ୍ଭ କରିବା ଏବଂ ସମାଜରେ ଶାନ୍ତି ବଜାୟ ରଖିବା। ଏଠି ସମସ୍ତଙ୍କ ଅଧିକାର ଅଛି ସମାଜରେ ଶାନ୍ତିରେ ଜୀବନଯାପନ କରିବା ପାଇଁ, ନିଜ ସମ୍ପତ୍ତିକୁ ଉପଭୋଗ କରିବା ପାଇଁ ଏବଂ ନିଜ ଶରୀରକୁ ସୁରକ୍ଷା କରିବା ପାଇଁ। ଏଇ ମଝିରେ ଯଦି କିଏ ଆସି ଷଣ୍ଢ ପୁରାଏ, ଆପଣଙ୍କ ଶରୀର କିମ୍ବା ସମ୍ପତ୍ତିକୁ କ୍ଷତି ପହଞ୍ଚାଏ, ତାହେଲେ ଆପଣ ଥାନାକୁ ଯାଇ ଥାନା ଅଧିକାରୀ ପୋଲିସ ବାବୁଙ୍କୁ ଘଟଣା ସମ୍ପର୍କରେ ସୂଚନା ଦେବେ ଏବଂ FIR ଫାଇଲ୍ କରିବେ। ଏସବୁ ନ କରି ଯଦି ଚୁପଚାପ ଆପଣ ଘରେ ବସି ରହିବେ, ତେବେ nobody can help you, and କ୍ରିମିନାଲ ଲର ବ୍ୟବହାର ହିଁ କମିଯିବ। ଯେଉଁ ଉଦ୍ଦେଶ୍ୟରେ ଅପରାଧ ଅଧିନିୟମକୁ ବନାଯାଇଛି, ପ୍ରତ୍ୟେକ ଲୋକଙ୍କ ସୁରକ୍ଷା ପାଇଁ ଦୋଷୀକୁ ଉଚିତ ଦଣ୍ଡ ପ୍ରଦାନ କରି ସେହି ସମାନ ଅପରାଧ ଯେମିତି ସମାଜରେ ପୁନରାବୃତ୍ତି ନ ହେବ ଏବଂ ସମାଜରେ ଶାନ୍ତିର ବାତାବରଣ ରହିବ ଏବଂ ଲୋକଙ୍କୁ ଉପଯୁକ୍ତ ନ୍ୟାୟ ମିଳିପାରିବ, ସେଥିଲାଗି ଏହି ନିୟମକୁ ବନାଯାଇଛି। ତେଣୁ ଏଠି ପ୍ରତ୍ୟେକଙ୍କ ଉପରେ କର୍ତ୍ତବ୍ୟ ନ୍ୟସ୍ତ କରାଯାଇଛି, ଯଦି କୌଣସି ଅପରାଧ ଘଟେ ତେବେ ତୁରନ୍ତ ଥାନାକୁ ଯାଇ ଏତଲା ଦେବେ, ତେବେ ଯାଇ ପୋଲିସ ମାମଲାର ତଦନ୍ତ ଆରମ୍ଭ କରିବ, ତାପରେ କୋର୍ଟରେ ଟ୍ରାଏଲ୍ ହେବ, ଅନେକ କଥା ରହିଛି। Alright, now the question arises that who can set the criminal law into motion or who can lodge an FIR? କିଏ FIR ଲଜ୍ କରିପାରିବ? Any individual, just a minute, any individual who possesses knowledge of the commission of a crime set the criminal law into motion. Any individual means anybody, you and me or anybody who possess knowledge of the commission of a crime can set the criminal law into motion. Means whenever a cognizable offense is committed, any person can approach a police officer and give him information regarding the commission of the cognizable offense. What I said, the word any person means it is not necessary that he or she should be the victim or eyewitness. Anyone who has information about the commission of a cognizable offense can lodge an FIR. A police officer can lodge an FIR on his own if he comes to know about the commission of a cognizable offense. There are two types of offenses. One is cognizable offenses, second is non-cognizable offenses. So, cognizable offenses means an offense in which a police officer has the authority to make an arrest without a warrant from the magistrate and to start an investigation with or without the permission of a court. Usually, cognizable offenses are those offenses which are serious in nature, like murder, rape, dowry death, kidnapping, theft, etc. Alright, then what is non-cognizable offense? It is just opposite of cognizable offense. Very simple. Non-cognizable offense means an offense in which a police officer has no authority to arrest without warrant, nor a police officer has the power to investigate into such offenses without the authority or permission given by a judicial magistrate. Usually, non-cognizable offenses are private wrong and these offenses are not much serious in nature. Cognizable offenses or cases are more serious in nature. Non-cognizable cases are less serious in nature. Example of non-cognizable offenses are assault, cheating, forgery, etc. So, whenever a cognizable offense is committed, any person who has information or knowledge about the commission of a cognizable offense can go to the police station. Which police station? Nearest police station, whether that police station comes within the jurisdiction of the place where offense is committed or not. It is not necessary to lodge an FIR in that police station only, within which jurisdiction or area or the location of the offenses has been committed. FIR can be lodged in any police station which is nearest to the place of occurrence or location of the incident. Very simple. If you have information about the offense committed or you are himself a victim, you can lodge an FIR. If the information is given to police cannot refuse to register FIR. Even if the alleged offense has been committed outside the territorial jurisdiction of the police station, FIR shall be registered. Shall means he must. He has to mandatorily register the FIR, and the same shall be transferred to the appropriate police station. No police officer can refuse to register an FIR. If the offense being reported occurred outside their police station's jurisdiction or area or location, the police is bound to register the FIR and forward it to the appropriate police station, which comes under the jurisdiction of that offense. This type of FIR is called zero FIR. What is zero FIR? Very important. ପ୍ରାୟତଃ ସାଧାରଣ ଲୋକମାନେ ଯାହାର ଆଇନ ଉପରେ ବିଶେଷ ଧାରଣା ନଥାଏ ସେମାନେ ଭାବନ୍ତି ଯେ କେବଳ ପୀଡ଼ିତା ମାନେ ଯିଏ ଅଭିଯୁକ୍ତକାରୀ ଯାହା ସାଙ୍ଗେ ଯିଏ କ୍ଷତିଗ୍ରସ୍ତ ହୋଇଥାଏ ବା ଅପରାଧରେ ଶିକାର ହୋଇଥିବା ବ୍ୟକ୍ତି ଏବଂ ତାର ସମ୍ପର୍କୀୟ ଲୋକମାନେ ହିଁ ଥାନାକୁ ଯାଇ ଘଟଣା ସମ୍ବନ୍ଧୀୟ ସୂଚନା ବା ଏତଲା ଦେଇପାରିବେ। ସେମିତି କିଛି ବି ନୁହଁ। ପୀଡ଼ିତା ନିଜେ ବି ଏତଲା ଦେଇପାରିବ ଏବଂ ଯେକୌଣସି ବ୍ୟକ୍ତି ମଧ୍ୟ ସେ ଘଟଣାରେ ପ୍ରତ୍ୟକ୍ଷଦର୍ଶୀ ହେଉ କିମ୍ବା ଯେକୌଣସି ବ୍ୟକ୍ତି ଯାହା ପାଖେ ସେହି ଘଟଣା ସମ୍ପର୍କରେ ସୂଚନା ବା ଘଟିଥିବା ଅପରାଧ ସମ୍ବନ୍ଧୀୟ ସୂଚନା ବିଷୟରେ ଜଣାଅଛି ତେବେ ବିଳମ୍ବ ନକରି ଯଥାସମ୍ଭବ ନିକଟସ୍ଥ ସ୍ଥାନୀୟ ଥାନାକୁ ଯାଇ ସେଠିକାର ଥାନା ଅଧିକାରୀ ପୋଲିସକୁ ଘଟଣା ସମ୍ପର୍କରେ ସୂଚନା ଦେଇପାରିବ। ତାପରେ ପୋଲିସ ତାକୁ FIR ରେଜିଷ୍ଟର ବୁକ୍ରେ ରେଜିଷ୍ଟର କରେ। ଏଠି ଗୋଟେ ଜିନିଷ ମନେ ରଖିବା ଆବଶ୍ୟକ ଯେ ପୋଲିସ କେବଳ ଗମ୍ଭୀର ଅପରାଧ ବା ଧର୍ତ୍ତବ୍ୟ ଅପରାଧ ମାମଲାରେ ହିଁ FIR ଫାଇଲ କରିପାରିବ। ସାଧାରଣତଃ ଅପରାଧ ଦୁଇ ପ୍ରକାର। ପ୍ରଥମ ଧର୍ତ୍ତବ୍ୟ ଅପରାଧ ବା ଗମ୍ଭୀର ଅପରାଧ ବା ସଂଜ୍ଞେୟ ଅପରାଧ ବୋଲି ବି କୁହାଯାଏ। ଇନ୍ ଇଂଲିଶ କଗ୍ନିଜେବଲ୍ ଅଫେନ୍ସ। ଦ୍ୱିତୀୟ ଅସଂଜ୍ଞେୟ ଅପରାଧ ଦ୍ୟାଟ୍ ଇଜ୍ ନନ୍ କଗ୍ନିଜେବଲ୍ ଅଫେନ୍ସ। ମାନେ ଗମ୍ଭୀର ଅପରାଧରୁ ଟିକେ କମ୍ ଗମ୍ଭୀର ଅପରାଧକୁ ଅଧର୍ତ୍ତବ୍ୟ ଅପରାଧ ବା ଅସଂଜ୍ଞେୟ ଅପରାଧ ବୋଲି କୁହାଯାଏ। ଏନିୱେ ସଂଜ୍ଞେୟ ଅପରାଧ ମାନେ କ'ଣ? ସଂଜ୍ଞେୟ ଅପରାଧ ସେଇ ଅପରାଧ ଗୁଡ଼ିକ ଯେଉଁଥିରେ ପୋଲିସକୁ ସମ୍ପୂର୍ଣ୍ଣ ଭାବେ ବା ଖୁଲ୍ଲମଖୁଲା ଅଧିକାର ଦିଆଯାଇଛି ଯେ ସେ ଅଦାଲତ ବା ମାଜିଷ୍ଟ୍ରେଟର ବିନା ଆଇନଗତ ଅଧିକାର ବା ବିନା ୱାରେଣ୍ଟରେ ଅଭିଯୁକ୍ତକୁ ଗିରଫ କରିପାରିବ ଏବଂ ଅଦାଲତର ଅନୁମତି ନେଇ କିମ୍ବା ଅନୁମତି ନ ନେଇ ମଧ୍ୟ ମାମଲାର ତଦନ୍ତ ଆରମ୍ଭ କରିପାରିବ। ଦଣ୍ଡ ପ୍ରକ୍ରିୟା ସଂହିତା 1973ର କେଉଁ ଅଧ୍ୟାୟ ଏବଂ କେଉଁ ଧାରା ଅନୁସାରେ ପୋଲିସକୁ ଏହି କ୍ଷମତା ଦିଆଯାଇଛି କମେଣ୍ଟ ବକ୍ସରେ ଲେଖିବେ। ବର୍ତ୍ତମାନ ପ୍ରଶ୍ନ ଉଠୁଛି ପୋଲିସକୁ ଏତେ ବଡ଼ କ୍ଷମତା କାହିଁକି ଦିଆଗଲା? ଭେରି ସିମ୍ପଲ। ଯେତେବେଳେ ପୋଲିସକୁ କୌଣସି ସଂଜ୍ଞେୟ ଅପରାଧ ବିଷୟରେ ସୂଚନା ମିଳେ ପୋଲିସ ବିନା ଡେରି କରି ଘଟଣାସ୍ଥଳରେ ପହଞ୍ଚି ମାମଲାର ତଦନ୍ତ କରେ, ଅଭିଯୁକ୍ତକୁ ଗିରଫ କରେ, ସାକ୍ଷୀ ପ୍ରମାଣ ଇତ୍ୟାଦି ସଂଗ୍ରହ କରେ। ପୋଲିସର ସମୟ କାହିଁ? ଯଦି ଏସବୁ ସୂଚନା ମିଳିବା ସଙ୍ଗେ ସଙ୍ଗେ ଘଟଣାସ୍ଥଳକୁ ନ ଯାଇ ଆକ୍ସନ୍ ନ ନେଇ ପୋଲିସ ଯଦି କୋର୍ଟକୁ ଯିବ ଅନୁମତି ଆଣିବ ଘଣ୍ଟାଏ 2 ଘଣ୍ଟା ସମୟ ଲାଗିପାରେ ମାଜିଷ୍ଟ୍ରେଟଙ୍କ ଠାରୁ ଅନୁମତି ଆଣିଲା ବେଳକୁ। ତେଣୁ CrPC ସମ୍ପୂର୍ଣ୍ଣ କ୍ଷମତା ପୋଲିସକୁ ଦେଇଛି କି ତୁମକୁ କୋର୍ଟକୁ ଦୌଡ଼ିବା ଦରକାର ନାହିଁ, କୌଣସି ଅନୁମତି ନେବାର ଆବଶ୍ୟକତା ବି ନାହିଁ। ଯଦି ଏହିଭଳି ଅପରାଧର ସୂଚନା ମିଳେ ସିଧା ଆକ୍ସନ୍ ନିଅ ସମୟ ନଷ୍ଟ ନ କରି। କିନ୍ତୁ ଦୁଃଖର ସହିତ କହିବାକୁ ପଡ଼ୁଛି ଆମ ଦେଶରେ ପୋଲିସ ଅପରାଧ ଘଟି ସାରିଲା ପରେ ଘଟଣାସ୍ଥଳରେ ଯାଇ ପହଞ୍ଚନ୍ତି। ସେତେବେଳକୁ ସେହି ଜାଗାରେ ନା ସାକ୍ଷୀ ଥିବେ ନା ଆଖପାଖରେ ଗୋଟିଏ ଲୋକ ଆସାମୀ ଚମ୍ପଟ ମାରି କୁଆଡ଼େ ଖସି ପଳେଇଥିବ। ପୋଲିସ ସ୍ପଟରେ ପହଞ୍ଚିଲା ବେଳକୁ ସେଇ ଜାଗାରେ 1-2ଟା ଛେଳି କୁକୁର ବୁଲୁଥିବେ, ଆଉ କେହି ନଥିବେ। ତାପରେ ପୋଲିସ ଆଖପାଖ ଏରିଆକୁ ଯାଇ ପଚରା ଉଚରା କରିବ, କାହାର ମନ ହେଲେ ସାକ୍ଷୀ ଦେବେ ନହେଲେ ନାହିଁ। ଏଇଭଳି ଦିନ ପରେ ଦିନ ଗଡ଼ି ଚାଲିବ ତଦନ୍ତ କରି ସମ୍ପୂର୍ଣ୍ଣ ତଥ୍ୟ ମିଳିଲା ବେଳକୁ ମାସ ଗଡ଼ିଯିବ। ତାପରେ ଯାହା ହେବ। ଏନିୱେ ସଂଜ୍ଞେୟ ଅପରାଧ ମାନେ ଗମ୍ଭୀର ଅପରାଧ ଯେମିତି ହତ୍ୟା, ବଳାତ୍କାର, ଅପହରଣ, ଚୋରି ଭଳି ଜଘନ୍ୟ ଅପରାଧକୁ ଗମ୍ଭୀର ଅପରାଧ କୁହାଯାଏ। ଓକେ, ତେବେ ଅସଂଜ୍ଞେୟ ଅପରାଧ କ'ଣ? ଅସଂଜ୍ଞେୟ ଅପରାଧ ହେଉଛି ସେହି ଅପରାଧ ଗୁଡ଼ିକ ଯେଉଁଥିରେ ପୋଲିସ ଅଦାଲତର ବିନା ଅନୁମତିରେ ବିନା ୱାରେଣ୍ଟରେ କାହାକୁ ଗିରଫ କରିପାରିବ ନାହିଁ ଏବଂ ଏହିଭଳି ଅପରାଧ ସମ୍ପର୍କରେ ତଦନ୍ତ ମଧ୍ୟ କରିପାରିବ ନାହିଁ। जुडिशियल मैजिस्ट्रेट को बिना अनुमति नहीं। यही अपराध संज्ञेय अपराध तुलन टिके कम गंभीर यथा आक्रमण, ठकामी, जालियाती इत्यादि। जेकोसी व्यक्ति FIR लॉज कर थाना को जाई। क्यों थाना? जोटा अति निकटस्थ। जेकोसी थाना रे जाई एतला दिया जाई परिबो। जदि से थाना अपराध घटी स्थान अति निकट रे अछि तेबे से थाना रे एतला दिया जाई परिबो। कौनसी प्रकार बाध्यतामूलक नुह एवं जरूरी भी नुह जे केउ स्थान रे अपराध घटी सेही क्षेत्राधिकार आसुथिबा थाना रे ही FIR लॉज होई परिबो बा से एरिया रो अंडर रे आसुथिबा थाना रे ही FIR लॉज होई परिबो बोली सेमिति किछि नाई। जेउ थाना अति निकटतर सेही थाना रे FIR दिया जाई परिबो। जदि दिया जाइथिबा सूचना अनुसार सेही थानार सीमा बा तार क्षेत्राधिकार बाहर आसे एहा परे भी पुलिस FIR रजिस्टर करने को मना करि परिबो नाही। पुलिस FIR रजिस्टर करने को बाध्य। तापरे से FIR को से थाना को तुरंत फॉरवर्ड करिवो जेउ थाना अधीन रे अपराध घटिथिबा स्थान आसुछि। एही भली FIR को जीरो FIR कहा जाए। No complaint can be dismissed merely on the ground of a police station not being within the jurisdiction limits of the place of commission of an offence. Got it? Alright. Now we will discuss that what are the remedies available when police refuse to register FIR. Also we will discuss the very important case laws and the judgment of Honorable Supreme Court relating to FIR. Okay. The police officer receiving such an FIR, such an information, has to mandatorily register the FIR. He has to register the information and give a copy of that information to informant, the person who has come to register the complaint. Subsection 3 of section 154 of CrPC states that if the police officer refuses to register the FIR, then the aggrieved person or the informant can approach SP, Superintendent of Police, for necessary direction. What we also need to understand is that police officer is bound to register in FIR whenever he receive an information with regard to commission of a cognizable offence. There was some confusion as to whether a police officer before registering the FIR can conduct the preliminary inquiry to ascertain the veracity of the facts or he has to mandatorily register the FIR. जेतेबेले पुलिस को संज्ञेय अपराध संपर्क में सूचना मिले पुलिस FIR रजिस्टर करने पूर्व सूचना मिलथिबा अनुसार घटिथिबा घटनार सत्यता जानिबा पई मामलार प्राथमिक तदंत बा अनुसंधान करिवार आवश्यक ना सूचना मिलिबा संगे संगे पुलिस को FIR रजिस्टर करिया बाध्यतामूलक. This controversy has been settled by the Supreme Court in the Constitution Bench pronouncement in the case of Lalita Kumari vs. State of UP 2014 to Supreme Court cases page number 1. This is a very important case law you must study. So little bit going story behind this girl. Lalita Kumari was a minor girl aged about 6 years. Went out of her house at 9 p.m. When she didn't return for half an hour, her father, named Bhola Kamat, went to the veranda out of his house for searching. He could not find her. Then he went to the police station, Ghaziabad, UP, and filed a missing report. But the police did not take any action on his complaint. Aggrieved by the inaction of the local police, the father of Lalita Kumari approached Senior Superintendent of Police. Even after registration of FIR and the direction of SP to subordinate police station to take action, but the police did not take any action to trace Lalita Kumari. Even the money was taken from her father to initiate investigation and to arrest, but no action was taken. Then finally, her father filed a writ petition in the Supreme Court under Article 32 of the Constitution for the issuance of writ of habeas corpus or direction. So, in this case, Honorable Supreme Court stated that the registration of FIR is mandatory under Section 154 of CrPC if the information received by the police with regard to commission of a cognizable offence. No preliminary inquiry is permissible in such a situation. It is the statutory duty of the police officer to register the FIR, and he has no discretion in deciding whether or not to register the FIR. Okay? When the offence is of civil nature or it is matrimonial offence, then in those cases a police officer can conduct preliminary inquiry. Otherwise, in normal IPC crimes such as murder, kidnapping, abduction, rape, dacoity, etc., the police officer has no discretion and he is bound to register the FIR. Bound to register the FIR means he has no other option. मान्यवर सुप्रीम कोर्ट को एक गुरुत्वपूर्ण राय ललिता कुमारी बनाम स्टेट ऑफ यूपी केस रे एवं किछि कड़ा नीति नियम पुलिस को पालन करिया पई आदेश दिया जाइछि। ए केस रे मान्यवर सुप्रीम कोर्ट स्पष्ट भाव में उल्लेख करिसंती जदि पुलिस को संज्ञेय अपराध संबंधी सूचना मिले तेबे पुलिस एफआईआर रजिस्टर करने को बाध्य बिना कौनसी प्राथमिक तदंत बा मामलार अनुसंधान करी प्रथमे एफआईआर रजिस्टर करने को बाध्य। यह छड़ा कौनसी निजस्व निष्पत्ति नेबा अधिकार पुलिस पाखरे नाही। लेट्स अंडरस्टैंड द नेचर ऑफ एफआईआर। Is it a substantive piece of evidence? FIR is not a substantive piece of evidence, nor is it the conclusive evidence of the facts which it mentions, but it can be used for contradicting or corroborating the maker of the report. Maker of the report means the person who gave the information to police with regard to the commission of a cognizable offence. एतलारे बा एफआईआर रे ଯେଉଁ ସବୁ ତଥ୍ୟ ବା ଫ୍ୟାକ୍ଟସ୍ को ଉଲ୍ଲେଖ କରାଯାଏ ସେହି ସବୁ ତଥ୍ୟ ସମ୍ପୂର୍ଣ୍ଣ ସତ୍ୟ ବା ଘଟିଥିବା ଘଟଣାର ପ୍ରକୃତ ପ୍ରମାଣ ବୋଲି ଧରା ଯିବନି କିମ୍ବା ଏତଲାକୁ ଆଧାର କରି ବିଚାରପତି ମହୋଦୟ ଅଭିଯୁକ୍ତଙ୍କୁ ଦୋଷୀ ବୋଲି ଘୋଷଣା କରନ୍ତି ନାହିଁ କି ଏଫଆଇଆର को ଆଧାର କରି ଦଣ୍ଡ ଦିଆଯାଏ ନାହିଁ। କୌଣସି ଶେଷ ନିଷ୍ପତ୍ତି ମଧ୍ୟ ନିଆଯାଏ ନାହିଁ। अभियुक्त को दोषी बोली प्रमाण करने गले साक्षी प्रमाण घटनार प्रत्यक्षदर्शी इत्यादि इत्यादि आवश्यक पड़ी था। एमती नुह जे एतला दायर कर क्या फाँसी खुंटर झुलैदेव ताल तो बड़ असुविधा हो। जो गोटे कथार अच्छी ब्रह्मा बिड़ी बिड़ेले बेदर गार या माने ब्रह्मा जदि शोईकी स्वप्न बाउली चाली हो कि कथा कही दिखती तेबे से सब बेदर गार बा सब सत्य बोली धरा जाए। एनीवे by substantive piece of evidence we understand that any evidence which can be used solely for the purpose of convicting the accused, and the FIR is not a substantive piece of evidence. Another important point is courts emphasize on lodging of prompt FIR. Prompt FIR means immediate, without delay, तुरंत बिना देरी करी। If there has been any delay in lodging FIR, it has to be explained. If the delay in lodging FIR is satisfactorily explained, it does not lose its evidentiary value. It has to be remembered that law does not fix any time for lodging the FIR, so delay in FIR is not illegal, but has to be explained the reason for delay, and the delay must not be unreasonable undue delay. The reason for avoiding to go to the police station immediately may be the time of occurrence, weather condition, distance to the police station, lack of communication, conveyance, illiteracy, lack of proper advice, etc. And also because of fear, threats by the adverse, and mental condition, illness, unconsciousness. For example, if the mother hear about her daughter committed suicide. So, all these are reasonable and valid reason for delay in filing FIR. କୌଣସି ସଂଜ୍ଞେୟ ଅପରାଧରେ ତୁରନ୍ତ ଥାନାକୁ ଯାଇ ଏତଲା ଦାୟର କରିବାର ମୂଳ ଉଦ୍ଦେଶ୍ୟ ହେଉଛି ପୋଲିସକୁ ତାଜା ସୂଚନା ମିଳିବ। ଯେଉଁ ପରିସ୍ଥିତିରେ ଏବଂ କେଉଁ ପରିସ୍ଥିତିରେ ଏବଂ କେଉଁଠି ଘଟଣା ଘଟିଛି ତାପରେ ସୂଚନା ମିଳିବା ପରେ ତୁରନ୍ତ ଘଟଣାସ୍ଥଳରେ ପହଞ୍ଚି ମାମଲାର ତଦନ୍ତ କରିବ। ଆସାମୀର ନାମ ଏବଂ ଯାହା ସବୁ ଘଟଣା ଘଟିଛି ସେହି ସ୍ଥାନରେ ସେହିସବୁ ବିଷୟରେ ପଚରାଉଚରା କରି ଯଦି କେହି ଘଟଣାର ପ୍ରତ୍ୟକ୍ଷଦର୍ଶୀ ଅଛନ୍ତି ତେବେ ତାଙ୍କଠୁ ପ୍ରମାଣ ସଂଗ୍ରହ କରିବ। ତେଣୁ FIR ଲଜ୍ କରିବାରେ ଡେରି କଲେ ହୁଏତ ସେହି FIRରେ 6କୁ 9 କରି ଲେଖିଥିବେ, ଟିକେ ପାଣି ମିଶାଇ ବଢ଼େଇ ଚଢ଼େଇ ମଧ୍ୟ ଲେଖିପାରନ୍ତି ଲୋକେ। ଆଉ ଏହା ବାସ୍ତବରେ ହେଉଛି ମଧ୍ୟ। ଯଦି କାହା ସାଥେ ଶତ୍ରୁତା ଅଛି କିମ୍ବା ରାଗରୁଷା ଅଛି ବହୁତ ଦିନରୁ, ତେବେ ସେହି ପ୍ରତିଶୋଧର ନିଆଁରେ ଜଳି ଯେତେବେଳେ କୌଣସି ଅଘଟଣ ଘଟିଯାଏ, ତେବେ ପ୍ରତିଶୋଧ ନେବା ପାଇଁ କିମ୍ବା ତାକୁ ହଇରାଣରେ ପକାଇବା ପାଇଁ ତା ନା FIRରେ ଉଲ୍ଲେଖ କରିଦିଅନ୍ତି। ସିଏ ଏମିତି କଲା ସେମିତି କଲା, ତାପରେ ସେଇ ଲୋକର ଅବସ୍ଥା ଯାହା ହେବ। ତେଣୁ ଏସବୁ ମିଛ କେସ୍ ଓ ମିଛ କାହାଣୀ ବନେଇ FIRରେ ଦର୍ଶାଇ ଅନ୍ୟକୁ ହଇରାଣ କରିବା, ଏସବୁକୁ ରୋକିବା ପାଇଁ ତୁରନ୍ତ FIR ଫାଇଲ୍ କରିବାକୁ କୋର୍ଟଙ୍କ ନିର୍ଦ୍ଦେଶ। ଯଦି ବିନା କୌଣସି କାରଣରେ ଉଦ୍ଦେଶ୍ୟମୂଳକ ଭାବେ FIR ଲଜ୍ କରିବାରେ ଡେରି ହୁଏ, ତେବେ ସେହି FIRର କୌଣସି ମୂଲ୍ୟ ନାହିଁ। ଖାଇ ପିଇ ଘରେ ଟିକେ ଆରାମରେ ସୋଫାରେ ଶୋଇ ନ୍ୟୁଜ୍ ଟିକେ ଦେଖି ତାପରେ ଥାନାକୁ ଯାଇ ଏତଲା ଦେବି, ପୁଣି ବାଟରେ ଗାଡ଼ି ଟିକେ ରଖି ଚା ସିଗାରେଟ୍ ମାରି ମିନାଜି ଗୋଟେ ପକେଇ ଯଦି ଯିବି ବୋଲି ଭାବିବ, ଏମିତି କଲେ କେମିତି ହେବ? FIRକୁ ଚିରି ପୋଲିସ ଫାଡ଼ିଦେବ FIR। ଘଟଣା ଘଟିଛି ଦିନ 10ଟାରେ, FIR ଲଜ୍ କରିବ ରାତି 7ଟାରେ, ସେ ବି ବିନା କାରଣରେ ଡେରି। So it may be rejected। ତେଣୁ ଯଦି FIR ଲଜ୍ କରିବାରେ ବିଳମ୍ବ ହୁଏ, ତେବେ ବିଳମ୍ବ ହେବା ପଛରେ ଗୋଟିଏ ଯୁକ୍ତିଯୁକ୍ତ କାରଣ ରହିବା ଆବଶ୍ୟକ। ଯେତେବେଳେ ପୋଲିସ କିମ୍ବା କୋର୍ଟ ପଚାରିବ ବିଳମ୍ବରେ FIR ଲଜ୍ କରିବାର କାରଣ ଦର୍ଶାଅ, ତାହେଲେ ଗୋଟେ ଭାଲିଡ୍ ରିଜନ୍ କହିବାକୁ ପଡ଼ିବ। ଯେମିତି ପୋଲିସକୁ ବିଶ୍ୱାସ ହେବ। ଯେପରି ପୋଲିସ ଷ୍ଟେସନର ଦୂରତା, ଗାଡ଼ିର ବ୍ୟବସ୍ଥା ନଥିଲା, ପ୍ରବଳ ବର୍ଷା ସହିତ ବିଜୁଳି ଘଡ଼ଘଡ଼ି ମାରୁଥିଲା। ଏହି ଘଟଣାର ଖବର ପାଇ ମୋ ଦେହ ଅସୁସ୍ଥ ହେଲା, ଚେତା ହରାଇ ବସିଲି, କିମ୍ବା ଘଟଣା ଘଟିବା ପରେ ଆମେ ହସ୍ପିଟାଲ ନେଇଥିଲୁ, ତେଣୁ ଥାନାକୁ ଆସି ଏତଲା ଦେବାର ବିଳମ୍ବ ହେଲା। କିମ୍ବା ଜଣେ ସ୍ତ୍ରୀ ଲୋକ ଘରେ କେହି ନଥିଲେ ଯେତେବେଳେ ଘଟଣା ଘଟିଲା, ସମୟ ସେତେବେଳକୁ ରାତି 10ଟା। ଏକୁଟିଆ ସ୍ତ୍ରୀ ଲୋକ ଅଧରାତିରେ ଥାନାକୁ ଯାଇ ଏତଲା ଦେବା ଅସମ୍ଭବ। ତେଣୁ ତା ପରଦିନ ସକାଳେ ଆସି FIR ଲଜ୍ କଲି, ଏମିତି କିଛି କାରଣ କହିପାରିବ। ତେଣୁ ଏଇଭଳି କାରଣ ଥାଇ ଏତଲା ଦେବାରେ ବିଳମ୍ବ କଲେ ପୋଲିସ ଗ୍ରହଣ କରେ। ଏହିସବୁ କାରଣ ଖାଲି କହିଦେଲେ ହେବନି, ପ୍ରମାଣ ଦେବାକୁ ମଧ୍ୟ ପଡ଼ିପାରେ ଏବଂ ପୋଲିସ କିମ୍ବା କୋର୍ଟକୁ ଏହା ଶୁଣି ବିଶ୍ୱାସ ଆସିବାର ଅଛି। So let's understand the second stage of pre-trial process, that is investigation. It is discussed under from section 156 to 159 CrPC 1973. So this picture highlights the procedure of investigation under CrPC. Investigation has to be done by the police. The purpose of investigation is to collect evidence. It is the statutory right of the police officer to conduct investigation for the purpose of collecting evidence, to identify the offender and proceed him for trial, and to give punishment as per the provision of the code. Section 156 of the Code of Criminal Procedure confers power on police officer to investigate cognizable cases. A police officer can investigate any cognizable offense without an order of a magistrate. But in relating to non-cognizable offense, the police officer has no authority to investigate without warrant. Such an order is necessary from the magistrate. The police officer has to obtain a warrant under Section 155, subsection 2 of the Code to investigate in relating to non-cognizable offense. Section 173 of CrPC requires that any police officer who is conducting an investigation has to submit his report to the magistrate after the investigation gets over, and on the basis of that report that the magistrate takes cognizance in the case. Another important aspect in the pre-trial stage, that is arrest. The main object of criminal law is to protect society from criminal and lawbreakers. Normally, we see a person who does or has done something against the law to be arrested. The term arrest can be defined as a seizure or forcible restraint to deprive a person of his or her liberty. The objective or reason behind the arresting an accused is to bring before the court and prevent him from escaping. If there is no threat that the person will run away, then there is no need to arrest that person. ଯେକୌଣସି ବ୍ୟକ୍ତି ଯଦି ଆଇନକୁ ଅବମାନନା କରେ, ଆଇନ ବିରୁଦ୍ଧରେ ଯାଇ କାର୍ଯ୍ୟ କରେ ବା କୌଣସି ଅପରାଧ କରେ, ସମାଜରେ ବିଶୃଙ୍ଖଳା ସୃଷ୍ଟି କରେ, ତାହେଲେ ସେହିଭଳି ଆଚରଣ କରୁଥିବା ବ୍ୟକ୍ତିଙ୍କୁ ଗିରଫ କରାଯାଏ। ଗିରଫ କରିବାର ମୂଳ ଉଦ୍ଦେଶ୍ୟ ହେଉଛି ଦୋଷୀକୁ ନେଇ କୋର୍ଟରେ ପହଞ୍ଚାଇବା ଏବଂ ଯଦି ସେ ଖସି ପଳାଇବାର ଉଦ୍ୟମ କରେ ତେବେ ତାକୁ ରୋକିବା ପାଇଁ ଗିରଫ କରାଯାଏ। ଯଦି ଦୋଷୀ ପୋଲିସକୁ ସହଯୋଗ କରେ ଏବଂ ଥାନାକୁ ଯିବା ପାଇଁ ପ୍ରସ୍ତୁତ ହୁଏ, ଯେତେବେଳେ ବି କୋର୍ଟ ଆଦେଶ ଦେବ ଦୋଷୀକୁ କୋର୍ଟରେ ଉପସ୍ଥିତ ହେବା ପାଇଁ ଏବଂ ଦୋଷୀ କୋର୍ଟର ଆଦେଶ ପାଳନ କରି ଉପସ୍ଥିତ ହୁଏ, ତେବେ ଗିରଫ କରିବାର ଆବଶ୍ୟକ ନାହିଁ। There is a landmark case of Supreme Court in the case of Virendra Kumar Rai versus Union of India, Criminal Law Journal, 1992. This is the case of 1992. In this case, Honorable Supreme Court held that arrest does not need to be by handcuffing the person. Arrest can also be made by spoken words if the person submits to custody. When a police officer comes to arrest a person and says, "You are under arrest," then the such arrested person, if he cooperates police and submit himself to the custody or agrees to go to the police station with the police, then in such case no need to put handcuff on such arrested person. Not even the police has power to touch that person. Very important. Arrest can also be completed simply by spoken words. Got it? Subsection 2 of Section 46 of CrPC states that if such person forcibly resists the endeavor to arrest him or attempts to evade the arrest, then such police officer may use all means necessary to effect the arrest. Means police can use all necessary forces to make the arrest complete if such person tries to run away or tries to escape from the arrest. So friends, arrest itself is a big chapter and very important also. So we will discuss in detail in the next video lecture. बहुत आगुरु जेतेबेले आईन बा नीति नियम एतेटा कड़ाकड़ी नथिला गिरफ करने संपर्क में एवं किपरि अभियुक्त को गिरफ करने दरकार एवं जड़े गिरफ होता व्यक्तिर कौन कौन अधिकार रही आम आईन रे यही सब विषय एतटा स्ट्रिक्ट रूल्स नथिला एवं तार परिचालना भी सठिक भाव में करा जाउ नथिला जाफल कौन व्यक्ति को गिरफ करने समय प्रथमे हाथ गोड़ी पिंधा जाउथला ଟାଣି ଓଟାରି ପୋଲିସ ପଛରୁ ଧକ୍କା ମାରି ଥାନାକୁ ନେଇଯାଉଥିଲା। ଗିରଫ କରିବାର ମାନେ ଏହା ନୁହେଁ ଯେ ସିଧା ଯାଇ ହାତକଡ଼ି ପିନ୍ଧେଇବା, ତା ଉପରେ ମାଡ଼ି ମୁଡ଼ି ଠେଲା ପେଲା କରି ଧରି ଥାନାକୁ ନେଇଯିବା। ଏହାକୁ ନେଇ ସୁପ୍ରିମକୋର୍ଟର ବହୁତ ଗୁଡ଼ାଏ ଜଜମେଣ୍ଟସ୍ ଆସିଲା, ଗାଇଡ଼ଲାଇନ୍ସ ଦିଆଗଲା। କୌଣସି ବ୍ୟକ୍ତିକୁ ଗିରଫ କରିବାକୁ ହେଲେ ହାତକଡ଼ି ପିନ୍ଧେଇବା ନିହାତି ଆବଶ୍ୟକ ନାହିଁ। ଯଦି ସେହି ବ୍ୟକ୍ତି ଚୁପଚାପ ସହମତି ହୁଏ ଥାନାକୁ ଯିବା ପାଇଁ, ଏମିତିକି ପୋଲିସର ଅଧିକାର ବି ନାହିଁ ସେହି ବ୍ୟକ୍ତି ଦେହରେ ହାତ ଦେବାକୁ, ଟିପଟେ ବି ଛୁଇଁ ପାରିବ ନାହିଁ। ଓକେ। ଆଉ ଯଦି ଗିରଫ କରିବା ସମୟରେ ଖସି ପଳାଇବାକୁ ଉଦ୍ୟମ କରେ ବା ଥାନାକୁ ଯିବାକୁ ରାଜି ହୁଏ ନା, ପୋଲିସକୁ ସହଯୋଗ ନ କରି ଡିଆଁ ମାରୁଛି, ତେବେ ପୋଲିସକୁ ସମ୍ପୂର୍ଣ୍ଣ କ୍ଷମତା ଦିଆଯାଇଛି ବହେ ଖୋବିବା ପାଇଁ। ଏହିଭଳି ପରିସ୍ଥିତିରେ ପୋଲିସ ହାତକଡ଼ି ପିନ୍ଧେଇ ପାରିବ। Here you can see the Bollywood superstar Sanjay Dutt. Though he is not resisting the arrest, nor he has intention to run away, but police is taking him to the police station by handcuffing. Here you can see handcuff. Here he is simply standing, but police has handcuff. You can see. So this is because at that time when he was arrested, there was no such strict law. Otherwise, he would not be handcuffed by the police. Anyway, so there are two types of arrest. Number one, arrest with warrant, that is issued by the magistrate. Number two, arrest without warrant. So next point, who has authority to arrest? The arrest can be made by police under subsection 1 of section 41 CrPC, also read section 46. Arrest can be made by magistrate under subsection 1 of section 44 of CrPC. Arrest can be made by a private person under section 43 of CrPC. Private person means like you and me. Anybody can carry out an arrest of a person if any cognizable offense is committed in his presence. Another important aspect under the pre-trial stage, that is search and seizure. These are provided under section 165 to 166 CrPC, that is the Code of Criminal Procedure 1973, which authorizes a police officer to make a search for investigation without the warrant. But this can be done only when there are reasonable ground for doing so. Basically, this power has given under CrPC to police to search any place, things, articles or documents, anything which is related to the case for which he has been authorized to investigate on such matter. Search is made by police during the investigation. Search cannot be made if the police officer has no authority to investigate on such case or an offense. ପୋଲିସକୁ ସମ୍ପୂର୍ଣ୍ଣ ଭାବେ ଅଧିକାର ଦିଆଯାଇଛି ଯେ ସେ ଯେକୌଣସି ଜାଗାକୁ ଯାଇ ଭିତରେ ପଶି ସର୍ଚ୍ଚ ବା ତଲାସି କରିପାରିବ, କିନ୍ତୁ ଯେଉଁ ଜିନିଷର ତଲାସି କରୁଛି ତାର କେସ୍ ସହିତ ସମ୍ବନ୍ଧ ଥିବା ଦରକାର। ଯଦି କେସ୍ ସହିତ ସମ୍ବନ୍ଧ ନାହିଁ ତେବେ ସର୍ଚ୍ଚ କରିପାରିବ ନାହିଁ। So here in search proceeding, one important aspect that we must understand, the rule of ad alteram partem does not apply to search proceeding. Ad alteram partem means, basically it is a Latin phrase which means listen to the other side or to give someone opportunity to defend himself or to say something. So whenever a police officer is conducting investigation and during that process any person against whom the investigation is initiated will not get the opportunity to defend himself. If this is allowed, it will defeat the very object of this proceeding. For this reason, the rule of odi alteram partem does not apply at investigation stage, particularly in search proceeding stage. Therefore, if the person has to say anything with regard to search proceeding, then he will be given an opportunity at the time of trial. Odi alteram partem माने होची कौनसी कार्य किंबा निष्पत्ति नेबा पूर्वरु उभय पक्ष को शुणिबा गोटे पटे शुणी निष्पत्ति निया जाए नाही आ गोटे पक्ष को मध्य कहिबाकू मौका देबा आवश्यक किंतु एही अधिकार इन्वेस्टिगेशन स्टेज किंबा सर्च प्रोसीडिंग स्टेज रे अलाउ नाही पुलिस को ता काम करबाकू देबा दरकार इन्वेस्टिगेशन बा सर्च समय रे बाधा न दे पुलिस को सहयोग करबा आवश्यक जहाँ भी प्रश्न बा जहाँ किसी सर्च मामला को नहीं कहबार अच्छी तेबे से लोक ट्रायल समय रे कहि पारिबो so the last concept of pre-trial stage and also the last topic of this lecture which is very important, that is remand. What is remand? A person who has been arrested without a warrant cannot be detained for more than 24 hours. However, if further detention is necessary and the investigation is not completed within 24 hours of arrest and the accused is further required in custody for the successful completion of investigation, then police can take the accused in custody for some more time, but after obtaining an order from a judicial magistrate, which is known as remand. And the power of ordering remand is given to the judicial magistrate under section 167 subsection 2 of the CrPC, the Code of Criminal Procedure 1973. The purpose of remand is to complete the investigation. When the investigation is not completed within 24 hours of arrest, then the police officer can take the accused in remand for more time. Thus why remand is an important component in the investigation process. So here ending the stages of pre-trial. See you next with another video lecture. Thank you so much. Take care. Have a good day.